The bone of contention in the application was whether there was meaningful consultation and the delay in the applicants coming to court instead of using internal remedies. Minister of Mineral Resources and Shell believed there was substantial consultation. The applicants argued that there was no proper consultation as the notice was published in 4 newspapers that do not circulate in the area. The notice was also published in English and Afrikaans, although the majority of the residents speak isiXhosa. The Mineral Resources Ministry questioned the time the applicants took to come to court, adding that they were aware of the planned seismic survey.
The other issue is perhaps more en passant, and that is the mention that the minister didn't become involved in the issue relating to internal appeal. Perhaps the answer lies here, in my lord and my lady, is that the situation is possibly similar or comparable to a situation where a administrative tribunal or organ or even a judicial officer is asked to recuse himself not because there is bias, but because of a perception of bias. And it's probably prudent for the minister not to have got involved with that issue at all.
The applicants in the main application also argued that Shell did not have environmental authorization as per regulation to conduct the seismic survey. But Shell says at the time, when applying for the exploration rights for the first time, this was not a requirement. The petroleum giant believes another court will have a different view on the matter.
In order to get where the applicants have reached on the point of consultation now, they ought to have challenged Regulation 3 as unconstitutional and sought to have it set aside. And our submission is that in the absence of having challenged that regulation, they couldn't succeed in persuading this court, or they shouldn't have succeeded in persuading this court that there was inadequate consultation.
The respondents believe there's no prospect of another court reaching a different conclusion.
On each of the grounds of review, they effectively made new law. So they made legal findings which other courts in our legal history haven't gone as far to make those type of findings. So I'm not saying I don't believe that they were wrong at all, but it is important that a higher court such as the Supreme Court of Appeal would hear a matter such as this, because it is of importance not only to business, other stakeholders, but indeed to the whole country and the public.
Judge President Benenge indicated that the judgment on this leave to appeal application will be delivered before Christmas. Gqeberha, SABC News in Gqeberha.